Hi, my name is Adriana Robinson, and I am an attorney with Grossman, Young, and Hammond. Today is Wednesday, June 24th, 2020. This past Monday, the U.S. Citizenship and Immigration Service announced a new rule that will significantly affect the employment eligibility requirements for asylum seekers. Some of the changes that we will see as a result of this new rule are that all individuals seeking an employment authorization document based on a pending asylum application must wait 365 days from the receipt of their asylum application before they can file an application for employment authorization. Under the current rules, a person who files for asylum must wait 150 days before they can apply for a work permit. Under this new rule, instead of waiting 150 days, they will now have to wait 365 days. Individuals who file their asylum application 1 year after their arrival to the United States will not be eligible for a work permit unless and until an asylum officer or an immigration judge determines that an exception to the 1 year deadline applies. So traditionally, asylum applicants or an individual who comes to the United States who wants to apply for asylum should apply within the year after their arrival. If they apply after a year, they would have to show that they qualify for an exception to what is known as the 1 year deadline. Currently, if an individual files after 1 year of being in the United States, they can still apply for an employment authorization document up until their application is resolved. Under this new rule, unless a person qualifies for one of the exceptions to the 1 year deadline, they will not be eligible to receive work authorization. In addition to aggravated felons, individuals convicted of certain lesser criminal offenses will not be eligible for a work permit. Individuals who entered or attempted to enter without inspection will not be eligible for an employment authorization document unless they qualify for one of the very limited exceptions. So currently, when a person comes into the United States and they come in without inspection, meaning they do not come in through a designated port of entry, they can apply for asylum and they can still be eligible for work authorization. Under this new rule, if a person comes in without inspection, meaning they come in not through a designated port of entry, they will not be eligible for a work permit unless they qualify for one of the very limited exceptions under the new rule. USCIS will now determine validity periods for initial and renewal work permits, but such periods will not exceed 2 years. And USCIS may also set shorter validity periods. Applicant cost delays unresolved by the date the application for a work permit is filed will result in the denial of the application for employment authorization. So, for example, if a person is scheduled to appear at the asylum office for their interview, and for whatever reason they have to reschedule the interview, that may be considered, if the applicant reschedules their interview, that may be considered an applicant cost delay, which may result in the denial of their application for employment authorization. This new rule does not alter the eligibility criteria for asylum, and the new rule will be effective on August 25th, 2020. If you have any questions about how this rule will affect you, please do not hesitate to reach out to us at www.grossmanyoung.com. Thank you for your time.